So, now some words about the structure of the federal judiciary. The Supreme Court is the only real part of the judiciary discussed in Article 3 of the Constitution, with the idea that lower courts shall be created as needed. In the aforementioned Judiciary Act of 1789, Congress set up various lower courts that would take some of the caseload away from the Supreme Court and make things run more smoothly in general. They've continued to expand as needed, but even now the federal judiciary is clearly overworked, and the system relies on opposing attorneys to work together to plea bargain or resolve most cases, preventing the system from becoming completely paralyzed by the incredible volume of cases it sees. The trick was determining what the jurisdiction of each of these courts was. Jurisdiction is basically a legal word defining which court has the authority to hear certain cases. And, which court should be in charge of which cases. You have all these different cases that need to be heard. How do we know where you go to do that? This can apply to geography, legal issues, and a number of other issues, and becomes an incredibly important point in case law. My intro to law class way back in undergrad spent probably half the semester talking about different types of jurisdiction, how jurisdiction is established, etc., etc., but I'll give you an incredibly brief overview here for federal courts versus state courts, the ones we care about in American government intro classes. Federal courts have jurisdiction on cases concerning federal questions. Clear enough, yes? Okay, well, what does that mean? It means anything involving a disagreement on federal law, which is typically something that either crosses state lines or a small handful of issues that aren't dealt with at the state level. Crossing state lines in the commission of a crime or business deal is obviously a pretty easy threshold to meet in a number of cases, so when the federal government wants to get involved in a case, they usually can. This is typically on high-profile cases like terrorism, think the Unabomber or Timothy McVeigh, but also applies to cases where a crime was committed on federal property or land, or crimes committed against federal officers. Federal courts also have jurisdiction on cases involving citizens of different states. So if someone from Virginia sues someone from Maryland, this case would likely have to proceed in a federal court. The vast majority of cases, though, violate state law, which helps the federal courts keep the load down quite a bit. But even that, they still see more cases than they can reasonably handle. The collective action problem I wanted to talk about the rest of this class is the principal-agent model in the courts, and how that affects the different actors in the system and how these issues are resolved. The Supreme Court acts as the principal in the federal court system, and lower courts are supposed to be agents. There are two types of jurisdiction here: original jurisdiction and appellate jurisdiction. Original jurisdiction means that a court is the first place to hear a case. This means that evidence is introduced, witnesses are called to testify and are cross-examined, and a judge or jury issues a decision on the facts of the case. Appellate jurisdiction is where another court has already heard the case and made a decision, but one side is arguing that the original court made an error in terms of enforcement of the law. This is not about reintroducing evidence or finding new evidence. It's only about when a court made an error in terms of interpreting the law in the original trial. A case can then be reversed, which means that the original ruling is, reversed to the opposite of what it was. But it also can be remanded, which means that it's sent back to the original court to be reheard, but with the error fixed, or it can be upheld, which means the original court was correct, stop your whining. The Supreme Court is almost exclusively a court of appeal, hearing cases that come up the pyramid to it from the lower courts. In over 200 years, the court's only heard somewhere around 150-160 cases under original jurisdiction. These are typically cases that affect ambassadors, public ministers, or consuls, cases in which a state is a party, cases involving maritime law, or even the occasional case that needs to be expedited, like Bush v. Gore back in 2000 with the presidential election hanging in the balance. The vast majority of its cases are brought onto it by appeal. Because it can only hear so many cases, the Supreme Court relies on lower courts acting as loyal agents, interpreting the law correctly and consistently to make sure that the Supreme Court's positions are upheld.